Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. From the time I first started practicing for a law firm in 1994 until just recently, this has always been my most favorite time of the year. Oh, I love Christmas and I love Thanksgiving and all of that, but the really nice thing about this time of year in the legal profession is that for the most part, it's the time when people start to look to take time off after having had very busy, very long years. The other nice thing about it, frankly, is if I did have something to do in the office, you could have set off a bomb in that office and not killed anybody but me because everybody else was out Christmas shopping, which is fine. I mean, I like to be able to work alone anyway. So, I mean, that's why I work remotely from my firm. During this time of year, if you need to get anything done in the courts, you need two things. You need to know, first of all, where all the local golf courses are and whether they're open. And second, you need to know the judge's cell phone number in your case because likelihood is that you're not going to find him at the courthouse. The story for today is that for the most part, it's hard time to do content on the law because there's really very infrequently something to talk about. But today we have a really interesting thing to talk about, which is the Fani Willis Donald Trump case in Atlanta, Georgia. I've tried not to make too much of a secret of my disdain for Fulton County, Georgia. I think many of the judges in Fulton County don't play strictly by the book, and I think many of the prosecutors in that county don't play strictly by the book. And as a result, you have results like what happened in the YSL case, because that judge did play by the rule book and she enforced it equally on both sides. Love that, respect that a great deal. Today, the Georgia Court of Appeals issued its opinion disqualifying Willis in that case. Now, you may remember that the trial judge did not disqualify her, but certified his ruling for immediate interlocutory appeal. And of course, an interlocutory appeal is one that's taken in the middle of the case. And so that appeal was taken. It went up to the Georgia Court of Appeals. They initially kind of kicked it around a little bit there. It was supposed to go into oral argument shortly after the election. And then the Georgia Court of Appeals announced that it wasn't going to have oral argument and didn't give any clue about what else was going to happen. So I wasn't sure exactly what was going on, but it appears that they decided to determine the case on briefs. Now, the reason you write briefs and the reason that lawyers write them hopefully very persuasively is that sometimes courts do decide it just on the paper. And that's looking like that's what they did here. I'm not saying that they didn't also maybe go look on YouTube at the actual testimony and make some judgments on the basis of that, but it certainly looks like they did not come away with a favorable opinion of Fani Willis. So this is the opinion that was released today, December 19th, in Roman versus State, Schaefer, Cheeley, Meadows, Trump, Latham, Giuliani, Clark, and Floyd versus the state. And it begins by saying all these folks were charged in a 97-page indictment with RICO violations and other crimes in connection with an alleged conspiracy to unlawfully change the outcome of the 2020 presidential election. In 2016, you may recall that there were electors elected by the people of their state who did not vote for the people that they were indicated they would vote for. These were called faithless electors. And there was a movement to get as many of those to vote against Donald Trump as possible. Now, as it worked out, there were 300, he was supposed to get 306 electoral votes. He got 304 in the Electoral College, and he was named to the presidency. But this faithless elector scheme, which dates back to the days of Alexander Hamilton, they were called Hamilton electors at that time, it was designed to alter the results of the election. But there was no fraudulent intent. It was conducted out in the open with people deliberately arguing these people should vote against the way they were elected. And if they chose to do that, well, okay, that's on them. But as it was, they didn't have enough to actually make a difference. In 2020, President Trump suggested submitting an alternate slate of electors to the Electoral College and certifying a different electoral vote out of the state of Georgia. This could be determined to be fraudulent if it had been carried forward. There were some initial work on that. There were people who were named as alternate electors, but in the end, nobody ever submitted those names and there was never any controversy. Had there been a judicial controversy, had something been filed in the state court and those electors sought to be substituted for the ones that were elected, and the court approved of that, then there would have been no fraud whatsoever. The mere fact that there were alternate electors would not have been criminal. What makes it criminal is any fraud or artifice or deception or anything like that. So again, the hearing was held on the disqualification motion. The trial judge found an appearance of impropriety, and he found some other problematic areas, and he decided that the remedy would be to disqualify Wade. Now, here's the issue with Fani and Wade. So Fani and Nathan Wade got to a position where apparently they were bumping uglies or whatever you want to call it. They were an item, a couple, and he spent nights over at her house and that sort of thing. At least that's what the cell phone data showed. And there were some explanations offered in the hearing that maybe didn't sound quite exactly right. You can go back and watch the actual testimony of Fani Willis and Nathan Wade if you want to on YouTube. It might be really helpful if you really want to understand this case. The court, in handling this, made certain factual findings and conclusions of law. And the court goes into that in this opinion. Here's what the court says. Collectively, appellants assert numerous grounds to reverse the trial court's order, including that the trial court order imposed an improper remedy after concluding that D.A. Willis's prosecution is encumbered by a significant appearance of impropriety, not grounded on mere status alone, but instead resulting from specific conduct impacting more than a mere nebulous public interest because it concerns a public prosecutor. In response, the state says we didn't do anything wrong. Importantly, the state has not filed a cross appeal asserting that the trial court's finding of this appearance of impropriety should be reversed. Accordingly, whether the evidence presented to the trial adequately supported under the appropriate standard of review on appeal, its finding of the existence of an appearance of impropriety is not before this court. So let's unpack that. Basically, Fani Willis erred by not contesting that factual conclusion or that factual finding by the court. As a result, the fact that there was an appearance of impropriety is not before the court on this appeal. In other words, that hasn't been challenged, so it's now a good finding that's insulated from appeal. So after presenting this motion to the court, they asked for an evidentiary hearing, which they held. And both Fani Willis and Nathan Wade testified in that hearing. And at the conclusion of the hearing, this is how the judge summarized his findings. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, the court finds that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. For the record, I think that is an appropriate finding. I don't think they established an actual conflict of interest. But that doesn't mean that that's the end of the discussion. The other alleged grounds for disqualification, including forensic misconduct, are also denied. Here we have a problem, because clearly what she said violated the code of conduct and the standards for professional prosecutors, and she shouldn't have done it. And it did implicate the propriety of the trial, particularly as applied to both Mr. Trump and Mr. Roman. And as a result of that, recusal or disqualification, I should say, on that basis would have been perfectly appropriate. But again, the judge didn't go there. Nobody knows why. I'm sure that's the way he saw the evidence. I'm not suggesting he acted inappropriately. I'm just saying I disagree with his finding. The trial court's order goes on and says, however, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one of two options. The district attorney may choose to step aside along with her whole office and refer the prosecution to the prosecuting attorney's counsel for reassignment, or she can have Wade withdraw, allowing her to continue to move forward with the prosecution. The trial court made the following finding of facts in its order, and it goes through and it lists all of these, and it talks about how they went on these long trips and did all kinds of stuff at different resorts. And then they conclude in total, defendant points to an aggregate documented benefit of at most $12,000 to $15,000 in the district attorney's favor. Now, I don't know about you, but $12,000 to $15,000, that's a pretty hefty sum in my book. And I think that should have maybe weighed a little bit more heavily on the judge's decision here, the trial judge's decision here, but apparently it did not. And the reason it did not, apparently, is that they testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Well, if Mr. Wade wants to hand out $12,000 to $15,000 without benefiting the district attorney, I'm available whenever he wants to do that. And those of you who want to sign up, you have to get behind me. Such a reimbursement practice may be unusual and the lack of any documentary corroboration understandably concerning, yet the testimony withstood direct contradiction, was corroborated by other evidence, and was not so incredible as to be inherently unbelievable. Now, I have to tell you, there are a lot of people who take big issue with that fact, because the idea that you keep thousands upon thousands of dollars in your home in a city like Atlanta, just stuffed under the mattress, that calls for a suspension of disbelief that I'm just not ready to give you. And then the court finished with saying, despite after considering all the surrounding circumstances, the court finds that the evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. In addition, and much more important, the court finds, based largely on the district attorney's testimony, which was not very pretty if you want my opinion, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute in this case. And again, that makes some sense. It makes sense that she didn't hire Wade so that she could get a benefit and then use that as a rationale for prosecuting Mr. Trump. So that's probably a good factual finding there as well. And the appeals court says that although the trial court found insufficient evidence of an actual conflict of interest, it also concluded that the record made at the evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after Wade's initial contract in November, the district attorney chose to continue supervising and paying him while maintaining such a relationship. She further allowed the rather regular loose exchange of money between them without any exact or verifiable measure of reconciliation. Most importantly, were the case allowed to proceed unchanged, the prima facie concerns raised by the defendants would persist. As the district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. And as long as Wade remains on the case, that perception will continue. After concluding that there's no real actual conflict of interest, here's what the court says. However, an odor of mendacity remains. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Yet reasonable questions about whether district attorney and her hand-selected ADA testified truthfully or untruthfully about the timing of their relationship further underpinned the finding of an appearance of impropriety and the need to make proportional efforts to cure it. Now, here it's important to remember that what they are asking for is a change in the remedy. In other words, they are not directly taking on the factual findings here. They're saying that the factual findings that the judge made supported a much more direct and punitive remedy than what was actually done. Appellate courts don't make findings of fact. They deal with legal issues. Things that are committed to trial court discretion, like whether to believe a certain witness or not, those are things that appellate courts don't review, but they can and should review the propriety of the remedy imposed because the remedy is a creature of law, not so much a creature of fact. And so this is what the Court of Appeals decides. The appellants contend that the trial court's failure to disqualify Willis and her office was erroneous in light of the trial court's finding that the record established that the prosecution was encumbered by a significant appearance of impropriety. In the appellant's view, the trial court's forward-looking remedy did not cure the already existing appearance of impropriety and the odor of mendacity found by the trial court. Based upon the fact findings of the trial court, in its order, the state's failure to cross-appeal the trial court's finding of significant impropriety, we agree. So the Court of Appeals says, hey, you didn't appeal this finding of impropriety. That means you agree with it, and as a result, we find that the remedy is not appropriate. After considering carefully the trial court's findings in its order, we conclude that it erred in failing to disqualify Willis and her office. The remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed at times when Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. This is the rare case in which disqualification is mandated, and no other remedy will suffice to restore public confidence in the integrity of these proceedings. And then they go through some of the cases cited by the parties and say, look, these cases aren't on point. As we conclude that the elected district attorney is wholly disqualified from the case, the assistant district attorneys, whose only power to prosecute a case is derived from the constitutional authority of the district attorney who appointed them, they have no authority to proceed either. So then the court summarily disposes of the whole dismissal of the indictment claim, and it says, no, that's not going to happen. Now, as you might guess, because this is a hot-button issue, there's going to be a dissent. And in this case, Judge Land doesn't hide the ball. He says, I'm particularly troubled by the fact that the majority has taken what has long been a discretionary decision for the trial court to make and converted it into something else entirely. If the decision was solely about disqualification, that would perhaps be true because discretion is supposed to be exercised by judges when they disqualify attorneys. But in this case, you may remember that the court says, look, we're not looking at the findings of fact here. We're looking at the remedy, and we find that the remedy here didn't match the facts, that this is an abuse of the court's discretion, and as a result, Willis is going to be disqualified. It's often said that hard cases make bad law, but honestly, this is probably the only decision the Court of Appeals could have made. That's what I have for you today. Thank you so much for watching. If you have any questions, drop them in the comments down below. Like, share, subscribe, all those things all of us YouTubers ask you to do. And then when you have the opportunity today, do something nice for someone, and then come on back down here tomorrow. Join me at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.